the election voided, if you will, because there may be a group that is essentially dissatisfied with the person. They don't like them, they don't like their policy, they find that person unpopular or whatever. But in the absence of criminal action, I think it's wrong to recall somebody. And I think that ought to be a very, very, very important part of what we talk about when we take this up. It's not just a question of understanding what's on the books. It's a question of how we're going to change it. Thank you.
And Mr. McGarry.
Thank you, Chair. I certainly don't believe the recall
provision in our charter is a matter of our personal opinion, whether we agree or disagree with it, but we believe our citizens have the right to exercise the liberties therein, and they do, if they so choose. However, I do believe there are questions that are outstanding that I would hope are addressed by this process. I believe principally whether or not indeed the city of Chattanooga is governed by a three-step or a two-step process. I believe that is the foremost question that I would hope as a body we will be able to come to some conclusion over. At present, we know that it's being debated whether or not it is a two-step, three-step process. I would hope for all posterity that issue would be resolved here and now, whether or not it's a two-step, three-step process. To Councilwoman Robinson's concerns about a low number of citizens being able to overturn any given election, we all know that that's possible because historically there has been a low voter turnout in our mayoral races. And one of the reasons that is so is because historically we as a city have opted to have our elections in March versus November. A move, I understand, was purposely instituted to make voter turnout low. So I find it quite curious that we initiated our voting process in March to have a low voter turnout, and when we have a low voter turnout, now we're upset about it. I think to improve or rectify that seems to me the easiest way to do so would be to actually change our voting date from March to November. That's not exactly a recall provision per se, Chair, but I do believe that these two issues are very closely affected one to the other. And so, again, just to summarize, I would hope we would address whether or not we as the city of Chattanooga are governed by a three-step or a two-step process. We would make that clear. And then also I would hope, Chair, as we're addressing this recall issue, that we would, as a council, make a move. Certainly it has to go via referendum, but we as a council would initiate the process of moving our elections from March to November so that hopefully we can have a higher voter turnout.
All right, I'm going to focus our discussion a little bit here. Certainly the date of election is another matter. The first issue is cleaning up the recall provision. I'm certainly not adverse to bringing up and discussing both, but we're going to deal with recall first. As I understand it, there is state law that impacts what we are able to do by way of recall provisions in our own charter. In other words, it's not a wide open playing field, and it hasn't been ever since the legislature acted in this area. And it was for that reason the potential conflicts between the state law and the city charter that chiefly have led to most of the confusion. There's certainly some issue with the charter itself. But Mr. City Attorney, would you kind of guide us and focus us on what we can do and what we can't do in this arena? And go ahead.
The first thing I'm going to refresh your recollection about Section 3.18, which is the current charter provision. It says in the case of an official elected at large, a petition signed by qualified voters equal the number of at least 50% of the entire vote for all candidates for the office of mayor cast at the last preceding general municipal election. That's the key phrase. In the case of an official elected by district, that is namely you all, the petition must be signed by qualified voters equal in number to at least 50% of the entire vote for all candidates for the office of mayor cast in that district at the last preceding general municipal election. So for the mayor, it's citywide. For the council members, it's 50% of whoever voted for mayor in your district. And one of the issues here we found out from the threats, at least threats to recall two members of the council at the same time that the petitions were being circulated to recall the mayor, was that it took a very small number of people to recall want to switch from and the charter, by the way, went on to say, it was one of the things that certainly been superseded by state law, that there would be a special election held to determine whether or not a person was recalled. I'm going to go back to the state statute now and tell you what some of the significant differences are. Okay, the state statute is TCA 2-5-151, and the first difference, the first significant difference, is the petition shall be signed by at least 15% of those who registered to vote in the municipality or the county. Interestingly, if you'll see that's considering the recall of a person elected at large. It appears to me that this would make it virtually impossible for the voters, if you follow strictly this provision, to recall one of the members of the council. Because if you're dealing with 50% of those who are registered to vote in the municipality or the county, that's 15% of the larger whole. Not a percentage of your district. So that certainly is one area that you really need to think about what you need to do in that regard. Now the state law, as you notably set forth, probably requires what they call the three-step process. Step one is filing a recall petition. Step two is to having a vote as to whether or not the elected official should be recalled or not. And assuming step two is recalled, then step three would be to replace that person with somebody else. That is one of the questions that is presently pending before the court in litigation, and I really feel that question is likely to be answered in litigation in the next few months, probably before we would have to put a matter on the agenda for the August election. The other thing about the state law is it provides that the election shall be held. I'm trying to find that phrase. At the upcoming general, municipal, or county election. So it's not a special election, but it's a regularly scheduled municipal or county election, and there's a lot of ambiguity there. But we're not able to change under the state statute. The only thing we can change is the number of people who have to sign the petition. That's the sole thing that this council has the authority to change. Otherwise, the state law is going to supersede what we do.
Next up is Mr. Rico.
Yeah, well, you know, like the attorney said, the state law always trumps state, so why don't we just mirror the state law? Then there would be any problem with conflict.
There's one other thing is, you know, state law does change, and I do think that's one possible solution, whether it's one that this council wishes to entertain. You have a charter provision that says the right of the people to recall their officials is hereby recognized. See state law as to how to do it. Because if state law changes in the next 8 years, and then another incident comes up, say the voters want to recall a city judge, and the state law has changed in the interim, we would still have potentially a conflict between what the city charter told the voters to do to recall that person and what the state law did. Obviously, that doesn't reach the issue that Mr. McMahon discussed, which is apparently it doesn't establish, the state law doesn't establish the threshold for recall by district, which is, well, a different threshold, which is, to say the least, odd. Next up is Ms. Scott.
In reading the rules regarding recall, I don't remember ever seeing where there was a specific criteria that was put forth for what it took to recall a person, that there was no criteria. And it seems to me that some countries will dissolve parliament and re-elect a whole new body of people, and it can be for any number of things, and it doesn't have to be for malfeasance. It can be just for the fact that they're unhappy with those that are leading them. The third thing that I thought was interesting is that when I was reading the state law, it looked like that it allowed a city who did not allow a city after 1997 to reset the number required for a recall, which we did have. I mean, the city of Chattanooga, it looked like to me, had reinstituted the prior amended charter. And I know there's some discussion about whether that was just relating to the schools, but if you go back into the minutes and see what council discussed, it was not just about one little portion of the charter. There was an overview of the charter that seemed, by at least discussion, to include the charter and recodifying it, and I may not be using the right term, but re-adopting it with those amendments, which would still leave us with the number that we had originally required for recall. And my fourth comment is that it's really hard to sit in an arena like this and redraft legislation. And so regardless of how we feel right this moment, I would recommend that there would be a task force, perhaps of 3 people that are on the city council, to sit down and to discuss, and maybe the rest of the council people come if they wanted to, and then see if they could put forth a proposal that we could maybe decide to, use or not use, or at least discuss it with a little bit more of the homework done than what we have currently. Thank you.
The chair is going to recognize the city attorney, but with regard to that, I think the city attorney has sketched out for us the options that we have in this field are not very broad. And it was the chair's hope that the council could come to some sort of, even if it was a minor plurality of which direction we thought it ought to go. And certainly if we can't get there, I'd be happy to entertain your suggestion. One of the other issues that I think needs to be kind of hashed out is for example, if we get to the point where we say, well, we don't know what number is the right number, and Ms. Robinson talked about a survey of other municipalities to see what standard they may have established, that may be in order, but I don't necessarily think, given what we can do, I didn't think this was going to be terribly heavy lifting. I do understand it's going to be controversial no matter what we do, because there'll be a certain camp that says you're making it harder to recall yourselves, and there'll be another camp that says, oh no, we don't want to put our city through this again, over what they perceive are not substantial grounds. So no matter what we do, we're going to have people unhappy, and I think we all acknowledge that.
But if we could, I mean, if there is something that's sketched out, I think we ought to look at that.
Yeah, Mr. City Attorney.
I will ask my staff to survey the other charters of the significant municipalities, the larger municipalities in Tennessee, and see what their recall numbers are. I think we've already done it, but I certainly can't give you that information off the top of my head. Mrs. Scott's point, in 2002, the city council, with Mayor Littlefield and being the chair of the Legal and Legislative Committee, went through the charter from chapter 1 to chapter 17 or whatever 18, whatever the last one is, for the sole purpose, as I understand it, of correcting the references in the charter that refer to the old form of government, whereas the commission form of government, the mayor, and to make sure that the duties were properly assigned, the administrative duties of the mayor and the legislative duties of the city council. And in the process of doing so, they amended section 3.18, it's the one I read a minute ago, by deleting the reference to the school board, because between the school board went out of business in about 1997. So you're right, there was a total recodification. You used the correct word. It was a total recodification of the charter in 2002. one of the questions that's being litigated before whatever judge has been assigned the case of Littlefield versus the Election Commission. That is one of the issues in that case, and I think it will probably be resolved by that case as to whether or not that's changed the number or didn't change the number.
Thank you, Mr. City Attorney. Mr. McGarry, sir.
Thank you, Chair. I just wanted to clarify based on what I heard the city attorney say, because I think there's some things out there that until we get a clear answer to, they'll continue to, at least in my mind, be perplexing. So based upon what you read in TCA, the city of Chattanooga, A, does not have the authority to institute a two-step or a three-step recall process. Is that your understanding?
The statute, and I'll be perfectly blunt, the statute itself is not a model of clarity. Whether the statute itself provides a two-step or a three-step process will be subject to legal arguments. I know that Mayor Littlefield's office or attorneys are saying that it is a three-step process. It is my belief that the Election Commission attorneys, by their action, are going to say it's a two-step process. So that is going to be one of the key factors in the current litigation, and I think that factor will be resolved in the current litigation. And no matter which way it turns out, we'll not be able to change the state statute in that regard.
Follow-up question. We currently have in our charter, it says that when there is a recall petition that is certified by the Election Commission must call an election no less than 30, no more than 60. It's my understanding that the state overrules that. We cannot alter the election date, correct?
You are correct. The statute says, as I read a minute ago, it'd be the next general or municipal or general county election.
And finally, the state does not allow you to alter what sort of information you must collect in the recall. In other words, name, signature, so forth. We as a city could not alter what we must collect for the recall petition. The state law provides the information, at least with respect to signatures that are required. And going back to an earlier point, the state law does not say what grounds, if any, it would take to recall a person. It just requires that there be a petition that is appropriately signed by the requisite number of voters in the appropriate manner. So in summary, the only thing we can change as a city is the total number of signatures collected.
Yes, sir.
Thank you.
It was going to be Ms. Robinson. Mr. Rico, did she tell you what she was going to say? No? Is that a motion? Ms. Scott has a light wishing to be recognized.
I would ask, could the city attorney's office send us a copy of the wording for the amendment that was voted on in 2002? The requalification.
The amendment in
what went on the ballot and.
Yes, ma'am, I certainly can.
All right. So I think we're going to wait for a survey of other comparable municipalities based on the number. Based on what council is telling us, it appears that that's chiefly the decision we have to make. We also need to make a decision with regard to whether we want to make ourselves functionally recallable. Because under that reading of the state statute, it would require nearly every registered voter in a district to sign a petition to recall us. Mr. Benson, sir.
Yeah, I would like to get a definition of what is just cause for recall.
I think what the city attorney is saying.
That's what I'm trying to ask.
Yeah.
Okay, the State Tenure Act for teachers is a moral turpitude, a criminal act, I think. There's one other, insubordination, which wouldn't be so here, but the state statute for tenure defines cause. You mean they don't define cause in this at all? If you just don't like somebody, you can just petition to recall.
You're correct. It is not defined at all in the statute. There are other statutes which allow people to be removed from office for such things as criminal offenses and stuff like that. There are ouster statutes, which is an entirely different section of the state code, but it's not very broad about how people could be removed from office. I know we have only one example here in the city of Chattanooga, and that was a person who
did not live in our district.
Yeah, I think perhaps the confusion here is that recall can be just a simple disagreement with somebody's politics and opinion, and I think the view of some is that it should be more like an impeachment. And I don't believe we currently have any provisions on impeachment in our city charter, not from my recollection. And we don't. City council members are removable by this body, honestly, only if you don't show up for 3 months in a row. Then you're removable. So that might be something else you want to think about, is whether we ought to be removable for a cause beyond just not being here for 3 months in a row. Mr. McGarry.
Just final question, Chair. Of course, I certainly would look forward to the answers the City Attorney's Office would be able to give. At what point, if any, would this be open for public discussion? Would there be a public hearing on this issue, or are you entertaining that idea?
I let the public talk to me all the time. I mean, I presume that your constituents, if they're interested, are contacting you. And in terms of giving people a forum to say what they think the new standard for recall ought to be, I certainly would entertain that. However, I would be very sharp on the gavel, as I think it would be an invitation to people who have an axe to grind one way or another on the current matter in controversy. And the moment that somebody starts straying out into, you know, he's a bum, or I can't believe you did this to him, what a great man, I'm going to have to gavel people down. I think the smarter thing to do, it's a very, very limited thing that we can do here. So take input from your constituents. We're going to have some constituents that think this is a very unfortunate thing that the city's had to go through, and they're going to want the bar set up here. And then you're going to have others that say, oh, no, it ought to be right where we have it, or even lower. So, you know, they're going to vary on that, but I don't see it ending well if we just open up that podium to people to come here and talk about it, at least until the present controversy is over. It's my understanding this council wants to have something on the ballot in November. So certainly I guess we could wait until after August and then act. We could just defer this whole discussion, but the other thing I'm hearing from council members is hurry up and get to this. So those things run at cross purpose. And unless that controversy is over and I open up that podium to people just telling us what they think it ought to say, I'm not a betting man, but I would bet 2 out of 3 of the people that address us don't say, here's what I think the numbers should be. They're going to want to talk about the present controversy.
And I certainly understand the sensitivity to it. If I may, real quickly, I think part of your concern is that if we do this as a group, we will be identified as either protecting our seats or making it too easy. And one of the ways to safeguard that is to at least make sure we are at least inviting input when we discuss this, the same way we have with our redistricting process. Otherwise, at least it gives an opportunity for individuals to address this.
And I'll reiterate, I know everyone on this council always invites input from their constituents. It doesn't always have to be at a podium with a microphone. Mr. Rico, sir.
Yeah, the one thing that bothers me about the easy recall, it's not because, when my age and career where, I probably will be here much longer here on the council or dead. So it really doesn't matter. But, the thing about it, if you start making it so easy, there's 2 things that I'm afraid would happen. You'll have council people that will start making decisions based on make sure they don't get recalled, or you have good people not wanting to run for office because they say, well, again, if somebody doesn't like me or like my decision, they'll recall me. And that's something we really have to think about.
Ms. Scott has a light.
I guess I like the idea of public input, but I too don't think that the discussion that we ought to have should be basically about a venting session on, whether you want someone to be recalled or not. But if it was limited to, if you want to give a suggestion, or if you want to submit, some language that you think, the city council could consider, I think that would be fine. But venting doesn't help us rewrite legislation that should basically take us, you know, many years down the road with a fair process that allows the right thing to be done. And so that would be my suggestion. His only suggestions about ways that it could be done or ways that it would be improved would be the thing we would want to get feedback on if someone wanted to give it.
Thank you, Ms. Scott. And what we're going to do at this time is the city attorney is going to take some time to complete the survey of other jurisdictions in the state of Tennessee. And he will report back to us. We will take this up at a future date. And I tend to think, given that we are not meeting next week in approximately 4 weeks, that this matter will be right. At this time, we're going to go ahead and turn to the public input session on redistricting. As you know, we had committed to accepting public input in a myriad of ways on redistricting throughout this process, and we all committed to the public that it would be through the final vote. So since that is on for second reading tonight, if there's anyone in the